Welcome to my YouTube channel, Case and Code with Chandan. Today, we're focusing our explainer on a truly monumental legal clash. We're talking about a case that didn't just play out in a courtroom, but literally rippled through hospitals, pharmacies, and patients' lives all over the globe. The case is Novartis AG versus Union of India. Citation 2013, Volume 6, Supreme Court Cases, page 1. This 2013 Supreme Court decision is, hands down, one of the most significant pharmaceutical patent judgments in Indian history. It tackles a massive, incredibly complex question head-on. How exactly do we balance the intellectual property rights of giant drug companies with the fundamental human right to health and affordable medicine? Okay, let's dive into this. Here's our roadmap for today. We're going to quickly walk through the case introduction, break down the science of the two-stage invention, unpack the fierce Section 3D debate, look at the Supreme Court's ultimate verdict, and finally wrap up with the real-world market impact. Let's get started. Section 1. Welcome and Case Introduction. So to really set the stage here, picture this. India had to comply with the International TRIPS Agreement. This meant shifting from a process patent regime to a product patent regime. Suddenly, actual chemical compounds could be patented. Well, this massive shift sparked a legal saga that spanned nearly 2 decades. Back in 1996, the underlying compound was patented in the US, a patent known as the Zimmermann patent. Fast forward to 1998, and Novartis files an application in India. But because India wasn't granting product patents for medicines quite yet, this application went into a sort of holding pen, a mailbox filing. When the law finally changed, the application was opened, only to be rejected by the Controller of Patents in 2006. Novartis appealed to the Intellectual Property Appellate Board, which dismissed it again in 2009. But Novartis refused to back down, taking the whole shebang straight to the Supreme Court, which leads us to this landmark 2013 ruling. Section 2. The two-stage invention. Let's move along and see how the science of this actually builds. Back in the early 1990s, an inventor named Jörg Zimmermann created a real breakthrough compound called imatinib, which is primarily used to treat chronic myeloid leukemia. But in India, Novartis claimed a two-stage invention. Step 1 was that original imatinib freebase. Step 2 involved creating an acid addition salt from it, specifically imatinib mesylate. And finally, Step 3 was developing a highly specific beta-crystalline form of that salt. Now, Novartis argued that reaching this beta-crystalline form required distinct, intensive inventive research involving incredibly precise process parameters. They insisted this wasn't taught at all by the original Zimmermann patent. To them, this was a genuine, patentable leap forward, not just a minor tweak. Section 3. The Section 3D debate. Which brings us to the core legal puzzle of this whole case. Section 3D of the Patents Act 1970. What is it? Well, it's a uniquely Indian legal safeguard drafted specifically to prevent a practice known in the pharma world as evergreening. And evergreening is basically when a drug company makes minor, trivial modifications to an existing drug whose patent is about to expire, simply to get a brand new patent and artificially extend their market monopoly. It's like resetting the clock. Section 3D explicitly excludes from patentability the mere discovery of a new form of a known substance unless that new form significantly enhances the known efficacy of that substance. Now, you can probably guess how the two sides clashed in court over this. On one side, you have Novartis AG arguing their beta-crystalline form was a genuine, incremental invention. They brought in affidavits showing a 30% higher bioavailability in rats compared to the freebase. For them, that was a clear enhancement of efficacy. They also argued that while the older patent covered the salt to protect against infringement, it didn't disclose it enough to prevent a new, separate patent. On the flip side, the respondents, which included generic manufacturers and cancer patient advocacy groups, argued the drug was already anticipated by prior art. They demanded a super strict interpretation of therapeutic efficacy, basically arguing that Novartis was just trying to evergreen a drug they were already selling at exorbitant prices. Section 4. The Supreme Court verdicts. So what did the Supreme Court actually decide? Ultimately, they dismissed the appeals filed by Novartis AG with cost. To cut through all the dense legal jargon, the court essentially created an elegant, straightforward decision tree for Section 3D. It operates on a very simple if-then logic. Step 1. Is the substance merely a new form of a known substance, like a salt or a polymorph? If yes, you move right to Step 2. Does it show enhanced therapeutic efficacy? If the answer is no, the patent is rejected to stop evergreening in its tracks. If yes, only then can you assess it for novelty and inventive step as a genuine invention. The absolute crucial point here is how the court defined that word efficacy. They ruled that physical attributes, things like better flow properties, thermodynamic stability, or being easier to store, they just don't count. That is merely physical efficacy. Even that 30% bump in bioavailability was rejected because bioavailability is just a pharmacokinetic property. The court mandated strict therapeutic efficacy. That means you must prove an actual, superior curative effect on the human body. The new drug must actually heal the patient better than the older version. Just being easier to manufacture isn't going to cut it. Now, what's really interesting about this is how the court handled legal loopholes. The Supreme Court firmly rejected Novartis's argument, trying to separate what a patent covers versus what it discloses. The justices stated quite plainly, "We certainly do not wish the law of patent in this country to develop on lines where there may be a vast gap between the coverage and the disclosure under the patent by the artful drafting of its claims." Essentially, they ruled that you absolutely cannot use clever legal drafting to hide the true scope of your invention just so you can double dip on patents a few years later. Section 5. Real-world market impact. Let's pivot from the abstract legal framework and dive directly into the stark economic reality of this case. Pre-judgment, under exclusive marketing rates, Novartis held a strict monopoly. Post-judgment, the market was blown wide open to generic competitors. The interpretation of efficacy shifted from being super broad to strictly therapeutic. And most importantly, generic availability went from being heavily restricted, where Indian companies were literally forced to halt overseas sales, to being widely available. This single judgment is really what cemented India's vital global status as the pharmacy of the world. To really put this into perspective, consider this drastic drop in cost. During the monopoly period, this life-saving cancer drug cost patients roughly 1,20,000 rupees per month. I mean, that was completely unaffordable for the vast majority of patients. But post-judgment, with the market open to generic manufacturing, the price plummeted to roughly 8,000 to 10,000 rupees per month. That massive, life-changing cost drop is the real-world consequence of preventing evergreen. And the court wasn't operating in a bubble. They knew exactly what was at stake. In their obiter dicta, they specifically recognized the huge concerns of the international community. They actually noted warning letters sent by the World Health Organization and UNAIDS. These organizations had explicitly warned that if India granted this patent and halted the production of generic cancer and AIDS medications, it would have absolutely devastating global health consequences, especially for developing nations that heavily rely on India's generic supply. But, no legal ruling is completely perfect, and this explainer wouldn't be complete without pointing out a lingering gap. While the judgment provided a really clear bar against evergreening, it left some ambiguity regarding the exact clinical data required to prove therapeutic efficacy. Pharmaceutical companies now face a bit of uncertainty. They know that pharmacokinetic improvements like bioavailability aren't enough on their own, but they are left wondering exactly how much expensive clinical trial data is actually needed to protect genuine incremental innovations moving forward. Which leaves us with this final, provocative thought to consider. The Novartis judgment protected millions of patients by prioritizing accessible medicine over artificial monopolies. But as science advances, how will future pharmaceutical innovations balance the need to incentivize incredibly expensive, genuine R&D with the urgent, unyielding demands of global health needs? It's a delicate balance for sure, and one that courts around the world will be grappling with for decades to come. Thank you for joining me on this explainer. Keep questioning, keep learning, and I'll see you next time on Case and Code with Chandan.